Clemson University employee is without a job, and two others are under investigation this morning after comments about political influencer Charlie Kirk's death.
And the school has been under political pressure from Republican leaders on the state and federal level to take stronger action against their employees. Some leaders threatened to even pull the school's funding. South Carolina's Republican Attorney General Alan Wilson, who is also running for governor, also sent Clemson's president a letter.
It says in part, the First Amendment protects freedom of speech, but it does not shield threats, glorification of violence, or behavior that undermines the mission of our state institutions, end quote. Wilson also clarified that under state law, the school would not face criminal prosecution if the university fired faculty over the social media post, and that legal action on a civil level was a possibility.
Meanwhile, in California, a College of Sequoia's biology professor is under investigation after a student recorded him making controversial remarks about political commentator Charlie Kirk and his family during a lab day class. Take a listen.
I hope every one of his family dies, and their children, and their grandchildren, and their grandchildren, and their grandchildren to eternity.
All right, so kind of hard to listen to all of this, and we're getting flooded with it on social media. So we want to bring in Chief Legal Analyst Khalif Rhodes to talk about these cases locally here in the Charlotte region and across the country. You touched on it last week that there is a big difference in someone who works for a private company and what is federally protected here. So what can you kind of make of all of this that's going on, especially at an institution like Clemson that does receive federal funding?
I would have loved you when I was a professor as a student because you paid attention to last week's class, so it made me feel like
A+.
But no, seriously, these type of things, this conversation is something that's great for law school and now real world application. As I mentioned before, public versus private, that's the key focal point that you'd have to look at. And so, yeah, if you're a private citizen, if you're employed by a private company, you have zero to little protections in terms of the First Amendment. But if you're in a public setting, if you are a public employee, it's a different approach. And the standard is, are you talking about something that is a matter of public concern? Are you working as a forester and you're talking about, I don't like the fact that we're cutting down trees? Now that may be something that will be a higher level of protection because you're in that job and you're talking about your specific job. Additionally, if you are talking about things outside of the scope of your job, maybe on social media, you'd think that you would assume based on court law and precedent that you'd have even heightened protections because you're away from the job. Now, the issue is, and Alan Wilson talked about it there, you can't make threats. The second part of his statement, I'm not sure if that's what the First Amendment says, and I haven't seen much precedent that talks about the glorification of types of things, because you can have a First Amendment a right to negative things that I don't agree with, and it is still protected. It just can't bring other folks to violence. So I can't do things that are inciting violence. I can't make threats of violence. Yeah, those are clearly not protected. But the glorification, my view of it versus someone else's view may be entirely different. So I think that's a little bit misleading with his statement of that second portion. Completely agree with the first part of that. There's a number of cases that support that statement. But the second one, I think that would be viewpoint specific. I'm saying I don't like your viewpoint. And because I don't like your viewpoint, I'm going to terminate you. I think that would actually go against what the Constitution says.
So I feel like there's fear swimming around, like on all sides, fearful of people saying, I want to be able to say my truth without the fear of being fired. You got people on the other side that are maybe defending Kirk and what he stood for or what he said, and they're fearful that the other side's going to retaliate against them. So there's fear on all sides. Yesterday, Vice President J.D. Vance was on the Charlie Kirk podcast. He's now calling for people to basically turn coworkers in if they hear speech that sounds threatening or that someone might be celebrating the assassination. Any protections there? I mean, what about the person who's turning them in or the person who's being turned in?
This part of the conversation, if this was a brief, I'd say I'd incorporate my previous statements, right? So all of my previous statements, I'll incorporate in this. We're talking about, in this instance, a public employee. If we're talking about private employees, nothing that I'm saying right here would apply. But if you're a public employee, someone that works for the federal government, someone that works in state employment office, and you're in any capacity like that, I believe the government cannot chill your speech unless they show a compelling public interest, unless it's narrowly tailored, and they go through a number of other hurdles they got to do that. And so in this scenario where you're saying you're going to challenge and go after someone because of what they're saying and the content of what they're saying, that is content specific. And if you're attempting to chill speech, it has to be content neutral. And so I think that is a clear violation of the First Amendment. You telling individuals to look for and look out for certain types of speech and to now whistleblow on their speech, the specific type of speech, the content of their speech, that is a clear violation of the First Amendment.
But looking at South Carolina, if the Attorney General's already said, you're not going to see any legal prosecution. Now, he did make a note that civil matters, that there's no guaranteeing there's protections there. So how do you decide what to do if the AG of your state is saying, no, don't worry, you can fire them and it's not a violation?
I just think that he's setting them up for a lengthy amount of lawsuits. If you're saying that you can terminate someone for content-specific speech, not content neutral, then I think he's giving them misguided information, specifically based on the hundreds of cases that have come before our Supreme Court, our highest court in the land, that have talked about the limitations on speech, specifically content specific. These are not content neutral. He's making recommendations, Alan Wilson, in this scenario, of going against individuals for content specific speech, specifically talking about an individual, Charlie Kirk, and what you're saying about that individual, your specific speech. There is a mountain of case law that says you cannot do that. And unless you are narrowly tailored, compelling public interest, and a number of other things, and they wouldn't be able to point to that. So I think that right there is misleading in terms of that memo. I had a chance to read it. I agree with the threats, the violence, but everything else in there is not accurate in terms of what case law says.
Yeah, going back to school on what the First Amendment allows and does not allow. So, Khalif, thank you so much for that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.